I know you want to frame the shot. I'm too far from the mic. Okay. We'll reset the camera next time. Yep. Yep. Okay. Just give me a 3, 2, 1, and I'll start talking. Hi, Steve Barsh from Dream Adventures, one of the managing partners, streaming today from Philadelphia. We have another exciting show to you today. Welcome to Dream It Live. Every day we work with and invest in great early stage startups, but these days we're spending a lot of time sharing ideas and advice from some of the best in the business with a focus on how to survive and thrive during these really challenging times. As we go through this information, if you have questions, please put them in the comments. If you agree or disagree, please put them in the comments. Let us know where you're streaming in from. It's always great to know where the audience is coming in from. We're streaming to lots of different services today. Also, when you ask a question, and we'll try to bring this up a few times, when you ask a question, if it's for a particular guest, because we have 3 guests today, please let us know which guest it's for. Just make a note of that when you ask the question. Okay, let me introduce our guests today. We have 3 great guests who made time out of their day for us, which is greatly appreciated. We have Jim Marshall. Jim is from Silicon Valley Bank in the Bay Area. He's a banker on the front lines of all of this, and he's been at Silicon Valley Bank since 2012 and been part of the startup ecosystem in Silicon Valley for over 20 years. We have Kathryn Hickey, and Kathryn, I hope I pronounced this correctly, from PilieroMazza in Washington, D.C. She's been an attorney for about 12 years, and she's working very closely these days with a lot of startups and in and around the NVCA, the National Venture Capital Association, around affiliation rules. And we'll talk to Kathryn about that. Duncan Davidson joins us. He was on last week. Thanks for being on again, Duncan, from Bullpen Capital, also out in the Bay Area. Jim's out in the Bay Area too. Duncan's a serial entrepreneur. He's built several billion-dollar companies, and these days he spends more time as a venture investor at Bullpen Capital, focused on B2B and B2C startups that are pre-Series A. Let me frame today's conversation quickly, and then we'll get to our panel of experts that are really who are on the front line dealing with this almost minute by minute these days. So hopefully we can fill the audience in on what's going on. So the way I look at this, and this is my opinion, and we'll pull everybody else in, a lot of what's going on. So number one, startups are scrambling, trying to get this Paycheck Protection Program funding, the PPP funding. Most banks, as of last Friday, companies had to have an existing loan or line of credit. Some of the banks said, well, that's because we have these rules, know your customer, and anti-money laundering, AML, and KYC rules. Some people have said maybe banks were doing that because they want to make sure their loans are repaid first. So there's a little bit of an issue with that. It'll be interesting to talk about that today. And there's tons of confusion and a lot of pissed off companies out there. Over the weekend, banks like B of A seemed to relax those rules about depository clients. And some banks are apparently, taking in customers who have no previous relationship. And some banks, I read this morning, and Jim will pull you into this in a minute, Wells Fargo apparently stopped lending. They're done in the PPP program, not because of PPP, but other issues. So anyway, and SVB we'll talk about, I think is going to open later today. Last thing, just in my intro, affiliation rules. So there's been a lot of things that people have been trying to change, that if you have less than 500 employees, but it still seems like there's a lot of confusion if you're a venture-backed startup and you've got VCs. And we'll particularly talk with Kathryn and then weave in Duncan on those issues around affiliation. There was even an interesting TechCrunch article over the weekend. Most startups are still excluded due to affiliation rules. We'll weave that in. Let's bring in our guests. Again, if you have questions, please put them in the comment. If it's for a particular guest, let us know which guest it's for. Jim, you can only be on with us till 10:30 Eastern or Pacific. I know you have a lot going on. Thanks for making any time today. So we'd love to start with you. What's the latest? What's going on at Silicon Valley Bank and banking in general with PPP?
Well, thanks so much, Steve. Let me just step back a bit. We've come out and our executive team has said we have 3 priorities. We're going to support our employees and clients through this crisis first. We're going to lead with empathy, and we're going to adapt to rapid changes because this is all new territory for us. It's interesting. We haven't done an SBA loan in 25 years.
Wow.
But we've in less than a week, put a team of 200 people together and have developed a new process to first start with an expression of interest site, but really to operationalize this through a full digital new process that we plan to go live with later this afternoon. So this has been a Herculean effort to get this going. And I want to step back a little bit. Before this even happened, we, again, trying to lead with empathy, came out with our venture debt principal deferral program that we announced last week, which was really aimed to provide simple and immediate relief to our borrowing clients. So this is across the whole portfolio. Any of our clients with loans less than $10 million would be eligible to defer making principal payments for 6 months.
Wow.
So this is about 1,200 companies. We've already had 800 sign up to take advantage of this. This is a very simple one-page loan amendment agreement, all through DocuSign, and we'll be doing that through April 24th. So again, in a way and we have other programs coming for other segments of our business, but that was one thing we did immediately outside of the SBA and everything else to try to help our clients.
I just want to comment quickly. That's nice of you to give them 6 months right out of the gate. And why wouldn't they all ask? I guess if I was the venture investor, I'd be like, of course, if they're giving you 6 months, take it because you could use the breathing room. That's very nice of you guys to do.
Yeah, and we expect them all to take it. Again, it's about 1,200 clients that qualify for this. Again, there's certain parameters, but and we expect them to all do that again through April 24th. So we have several initiatives and programs coming up. Some, like I said, are brand new that we're implementing, and we're learning as we go here, but trying to be as responsive as we can.
Okay, that's great. So what are your thoughts? When do you think most FDIC banks are going to start accepting applications? Do you have a view? I know you work at SVB, Silicon Valley Bank, the bank of startups. But do you have a feel? Do you think in the next day or two, or are they now?
I really don't know. I think we saw a few banks kind of rush in to try to meet the Friday deadline, and there was some mixed feedback on that reaction. And we took a little bit of heat publicly for not being open on Friday to take applications, but we wanted to be really clear on what we could do, what the parameters of the program were, and to make sure we can satisfy the demand. So we've had about 8,000 companies express interest participating in this program. And we think we're going to, once we go live and process, who knows, it could be up to 10,000, 12,000 companies that apply for this, just at SVB.
Okay. And Duncan, can I ask, do you have a feel, how many companies are in your portfolio and about how many of them have applied at this point? Do you have a feel yet by chance?
We've asked them all to give us their feedback. We're getting that mostly today and tomorrow. So I don't quite know statistically yet. We've also counseled them. So first of all, I want to do a shout out to Jim and SVB. You guys are fantastic. You really do serve the venture community well, and I applaud you for all that you've done. Most of the other banks are I won't quite use the wrong word, but a stuff show. That's how they're handling this. What we also advise our companies, though, and this is an important thing just to note, is maybe you could get this loan, but you have to think of the broader societal and moral implications of asking. A lot of the companies can get through the COVID chasm without asking for this, and they might view it as free money, but they should really understand this is meant to keep your payrolls higher and not just give you a free bridge loan through the back door. So we have counseled them to have some sense before they run out and ask for this, do they really need it or not?
Okay. And Kathryn, same thing. Do you have a feel, can you give us an idea of how many startups you're talking to or dealing with today? And do you have any feel for how they're doing on applying to their banks and if those banks are now open for this?
Yes. And so first of all, Duncan, I have to say, I really applaud you and Bullpen for sending that message, because I do think that it's something that companies, I think, are focusing on more now that there's been a little more emphasis on the necessity piece for this loan. But at first, I do think that was, this is a very attractive loan. And so a lot of people want a piece of it. what we're seeing, and we've been working with a lot of companies, we've been working with funds as well as individual companies that are looking to apply. What we've heard is most banks, I think, are opening today. A few did roll out on Friday, I think, with mixed success. So, we've been hearing from our companies that they are starting to be able to submit applications as early as, I think, 9 a.m. this morning in some cases, and others are rolling out kind of mid-afternoon. Frankly, I think that, even getting things launched today was still hugely successful given the lateness of the guidance that came out end of last week and even over the weekend about the program. So I think that we are probably through the end of today and into tomorrow going to see the kinks being worked out of the system and hopefully the applications starting to be processed.
Okay. All right, cool. Sounds good. Jim, to come back to you, and by the way, if you're just joining us, thanks for tuning in. We have a great panel of experts with us today. We have Duncan from Bullpen Capital, Kathryn from her law firm, Jim from Silicon Valley Bank, telling us the latest and greatest on what's going on for the PPP loans for startups. Jim, what are you guys concerned for the people that you're working with? What's needed to get the application approved as quickly as possible? I mean, and I guess there's kind of a standard application. Is there anything that you're particularly worried about that startups should be focusing on to make sure they have the documentation? Yeah, I have my payroll report, but anything in particular you're worried about?
Well, we're trying to come up in our process with the required things that we think our clients, and our clients, again, are clients in the innovation economy, right? These are early stage tech and life science companies, just specific to them around ownership and some of the characteristics that would be more applicable to them, to make sure they address that early in the application process. So we're trying to make it as targeted as we can, but I don't have any more kind of insight along that, Steve, at this point. This is still moving time. That's fine.
What do you see, and maybe I'll open this up also for Duncan and Kathryn, and you can certainly chime in whenever you'd like. Do you worry or are you seeing mistakes being made in applications that are going on now, or you're talking with clients and they send you like, no, don't do that. That's a mistake. Anything that any of you are seeing right now? Again, it's still kind of early. People tried Friday. They're trying. SVB is opening this afternoon. But any mistakes any of the three of you are hearing or seeing or worried about? Duncan, anything?
Let me comment.
Sure.
Our quickest off the dime was in Cincinnati. Went to a local SBA approved bank. Did not go through the majors. Bam, they got in right away and it seemed to work. So just
worked, approved? Like, was it approved and they got the funds, or what do you just got the application?
They got the application in really quickly. There was no problem. And the bank seemed to be on top of all the rules. So the advice the bank was giving back to them was quite consistent with what, for example, the NVCA has been telling us, I think through Kathryn, as well as through Cooley. The second thing we've noticed is that the bigger the bank, the worse it is. So we have one company that applied this morning, and JP Morgan came back and asked them to attest to something which is totally nonsense. Like if any of your VCs had other people apply for SBA loans. Well, they're all doing it. So how can you ask this question? It's like,
that's not fair.
Duh. So and that's not what they're getting at. But the question is poorly framed. So we've also seen some other places like Chase seem to open up and then crash. There's just been a lot of problems. But the way I say it is, the bigger the bank, probably the worse the experience all the way down the line. Besides SVB, First Republic's doing a fair amount of this. They first said they weren't going to do it, then they said they were. They're now accepting applications. So I guess the experience is right now, today, most of our companies who want to apply are going to hit the systems, and we'll see what the feedback is. I will say that SVB's, the way they've been dealing with this is spot on. And the people we have a lot of SVB customers, and they are enjoying the process as opposed to scared of it. So again, Jim, shout out to what you've done there.
Thanks, Doug. And if I just may add something, I mean, one of the biggest challenges and questions I'm getting, if we're not an SVB customer, can they still qualify under the PPP? And that's a tough one. I mean, you have to be a client in order to qualify, because we have to go through the KYC in that process.
Know your customer, right? The legal requirement to know your customer.
Know your customer, but we're getting a really large increase in interest of non-clients who want to participate in this program, asking to come over and open up accounts, which we're trying to handle and we're trying to accommodate, but we have to focus on existing clients first, which I'm sure you can all understand. So anyway,
it was interesting over the weekend. I was communicating with one of our DreamIt portfolio companies, and they said they were a Bank of America customer that had quite the kerfuffle on Friday. And on their B of A, they said, we've been a customer of yours for 20 years. We've got, over time, 20 years. We have $5 million and we can't get money from you. And they said, no. They actually went to a different community bank, and the community bank approved them and said, we'll go ahead and do it. Brand new relationship. I don't know how they got around the KYC. Of course, B of A came back to them over the weekend and Sunday and said, we changed the requirements. Don't worry about it. And the DreamIt company is like, that's okay. We're done here.
Right.
We're totally done here. But anyway, Kathryn, again, the question is mistakes being made on applications or things that you're hearing from the field around the banking, because we're going to, the first half of the show, we're just going to talk on the banking side. Things that you're hearing and seeing.
Right. So at this point in the process, we are getting a lot of questions focused on the application itself and specifically how to respond to some of these items where on their face they seem like they should be simple. But then once you think about it a little bit more in the context of how some of these companies' ownership structures are set up, there's a little bit room for interpretation. And so we've actually been working with the NVCA to try to put together some consistent guidance on the best way that we think to approach some of these questions. The most fundamental being we have to list every owner of 20%, more than 20% of your company. So the questions we're getting is, well, what does that mean? Is that just the current issued and outstanding equity? Do we do it on a fully diluted basis?
Right.
There's no instruction for the application that tells you which to do one way or the other. And so, frankly, the guidance that we're giving is pick a method, make it clear which you're using, and be consistent because there's no indication that you have to pick one or the other. Kind of similarly, we've gotten questions around whether related funds, if you have an investor who comes in through Fund 1 and Fund 2, technically they're different record owners. If each of them owns 15%, do we need to list them in the aggregate as a 20% owner of the company? And the advice that I think is probably the best approach to take there is, whereas technically the form does not necessarily require them to be listed, because you are going to have to take into consideration the affiliation between those funds and whether or not that impacts the applicant's eligibility, and you're going to have to address that later in the form. It's best to treat them as aggregated and make sure that it's very clear that, for purposes of the common ownership, we're going to aggregate those related funds. And to the extent they collectively own more than 20%, we'll list them in the schedule. Those are the sorts of things we're getting a lot of inquiries about. And I understand why, because people want to get this right.
And is the best way to find those answers is the NVCA website, reaching out to you guys and your firm, but I'm a startup. Where can I get the most authoritative information these days? Are you finding?
Well, you can certainly reach out to your legal counsel, because if they are at all spun up on the CARES Act, they probably have some sense of this. NVCA's official recommendations on this, I think, should be coming out at some point later today. And then also have them reach out to their lender as well, because ultimately, regardless of what we say, the lender processing your application may have their own view of how it should be completed. So make sure that what you're giving them is consistent with their expectations.
By the way, for the piece from the NVCA, is that you? I guess it was an Aaron from Cooley wrote the first piece a few days ago. Are the both of you co-authoring that? That was terrific. It was incredibly helpful for funds.
This last one, I think, is not going to have a byline at all, because it's been a very collaborative effort among many lawyers, Cooley, PilieroMazza, and several other firms as well, Goodwin. So it's this one's a team effort.
Okay, that's awesome. Let me do. I'm sorry. Go ahead, Duncan. Yeah.
I just want to add, some of our companies have a different bank for checking account deposits and a different as for the venture loan. And there's some venture lenders like WTI, Western Technology, that are very common across the venture community, but they're not a bank and they're not participating in the program. Now, Maurice, the guy who runs it, has told us he encourages all his companies to go through the program if they qualify, and he will be supportive. We've had another bank that's encourage the particular entity to go to one of the top SBA lenders. In this case, a company called Newtek. I think it's number 2 in SBA, versus going through the B of A, Wells Fargo, whatever problem set. So you have basically a choice. If you have a venture lender who's not your deposit bank, you could still go through a process through them. And apparently the SBA entities, the banks, are approving, like community banks are approving, without the detailed KYC that maybe a B of A would go through.
Got it. Okay, let me keep going on the banking side because we have Jim for about 10 more minutes. We are going to get you on your team meeting on time, I promise. And again, I appreciate you making the time. These are 3 people that are extremely busy. Dream, it's busy too. So we appreciate you giving us time today to talk about this important issue for startups. So I wanted on the banking side, maybe Jim, we'll focus on you, back to you for a minute. Timeline for when loans should be processed. Like, what is SVB? I'm a startup, and by the way, full disclaimer, SVB is the bank for Dream Adventures as well as many, many venture funds. But what's the timeline for when a loan should be processed? So if I apply today on SVB, what's that timeline look like?
Steve, I wish I knew and could tell you that. I really don't. I am not. Okay. I am not part of our 200-person task force. And again, this is happening in real time.
Sure.
We're going to do our best to process this. I think we have, didn't the government say it's up to June 30 to actually process and fund these loans, which I know is not, hopefully we'll be through most of these by then, but I do not have a timeline. So I'm sorry, I can't.
Quick question. Kathryn, I saw you nodding. Is that correct? June 30th is when the banks have until?
Yes.
Is that correct? Okay.
Technically, yes. I mean, we're anticipating, and Jim, let me know if this is off the mark, that the actual processing will be much faster. But the loan program is going to be open through June 30th. So companies should be able to apply, assuming funds are still available, through the end of that term.
Got it. Okay, but Jim, just back to you for a minute. I know you don't know, but could you give us a hint, just an expectation? So let's say I apply to SVB or any of the other banks, and I know you particularly can't speak for other people. Are we looking, so let's say I get my application in today, and I know your website's going to be way overloaded. Are we measuring in hours, days, weeks, months? Do you think I can apply today? And if you have no idea, it's fine.
We're going to let the whole world know as soon as we know. so we don't know that yet, Steve. I'm sorry.
It's follow at SVB Financial or like at SVB Help, right? If your Twitter is going to be the best channel, I would assume, and you'll be emailing your customers.
Yeah,
as well.
We have a site now that's and I could maybe share the link on here of our PPP application page where
and I think
it's coming.
I think Dustin has a screenshot of it if you want to pull it up. But yeah, I think of the SVB page. Okay, cool. Let's keep going. So once it's processed, then let me ask Kathryn and Duncan, do you have any feel like what are your startups? There it is. There's what the application process on SVB. Yeah. Do you have a feel when, and Duncan, you have this great expression, default alive, make sure you're in default alive mode, that you're keeping your startup, that burn rate down. Do you guys have expectations for Kathryn or Duncan when startups should be receiving these funds? It's the classic, the deal's not done till the money is in your bank account. Any thoughts or expectations you have?
Well, I'm probably the furthest from this from a banker and a lawyer helping NVCA. But, the plan was almost the same day funding once they get their act together. In other words, the loan should be quick. Mm-hmm. And particularly, I hope with SVB, if you already have an SVB venture loan, it should be easy for them to top it off once the back end of the program works. So we're dealing with government time, so who knows? But I think it's supposed to be, when they get their act together, a very quick result. There's nobody in the background reviewing this. Nobody's going through your form and reviewing this. And this is very important to understand. You as a company are self-attesting to the accuracy of the application. Mm-hmm. You're self-attesting to affiliation and some of the other things in there. And of course, you get in trouble if you're not honest about it. But there's nobody behind you, no hordes of bureaucrats sitting back to review your application, which is kind of interesting. They're trying to get the money out quickly, is the point.
Okay. Kathryn, any thoughts on that?
That's consistent with our expectations. The whole program has been designed to move as quickly as possible. So to Duncan's point, they're not requiring that the SBA send investigators in to examine each applicant's application and eligibility and make a finding as to your affiliation. They're not doing that. Instead, they're putting the burden on the applicant, which means you have to be good that you have done your diligence, be confident in that and make sure that you're not acting recklessly and disregarding the rules when you submit your application, because ultimately, if there are issues, it's going to fall back on you. But the benefit of that is that it means the lenders can process these really quickly. The application is a 1.5-page form, 2-page form. It's very simple, check the box. And once the approval is processed, which should be relatively simple, we're anticipating the funds are going to be available, again, virtually same day. We'll have to see if that plays out that way, but I think that's the intent here.
Okay. All right. Thank you. Jim, we have 5 minutes left with you. We're going to be on time. Let me transition to some questions that have been asked already. They're going to come up on the screen. I'll read them to you too. It should come up on the bottom third if Dustin's ready. And then you're going to drop off in about 5 minutes, and we'll keep going with our other two guests, and we're going to transition more into affiliation. And by the way, there's one question that came up for Duncan that was a banking question, but we'll pull it in later. All right. So first question that came up for Jim: do you think banks will run out of funds? And then what happens?
It's a good question. I mean, each bank has to really look at their liquidity position and ability to fund these loans. I think we're in the process of doing that analysis. We don't have any firm data about what our bucket is for this, but obviously, the larger the bank, the more capability here. But okay. But that's an issue for sure. Is what's the capability for these banks?
Got it. Okay. Terrific.
Steve, can I comment for a second?
Absolutely.
Last week there was a problem in the banking community, and some of the big banks had these calls about it, where this is $350 billion, and if they add more, it might be $500 billion. We're $1 billion here, $1 billion there. We're eventually talking real money. They were worried that it would affect their bank lending practice, and they would become insolvent or violate bank rules. Apparently last week, and maybe Jim knows about this, I don't know, but apparently last week there was an important waiver given to the banks, and that's when they began to open their portals. Because this is supposed to work where the U.S. government guarantees these loans, so the banks are not really on the hook here, as long as it doesn't affect their bank capital requirements and all.
Right, but I believe that's why Wells Fargo shut down. They were exceeding that requirement, and they turned it off last night or something, is what I heard. Let me keep going. We have two more questions for Jim, and then 3 minutes left to get them out. Jim, next question that was up: how do I find out if my bank is an SBA-approved lender? So they need to be FDIC, but I guess this question was everything's like an SBA-approved bank. Like, is there a magic box, or how do I get that answer?
I'm not exactly sure. Most banks have COVID and PPA communication on their websites now. All right. So I would just reach out to your relationship manager at whatever bank you're at to figure out if you're participating, or do a search online.
Okay.
I can jump
Kathryn?
in.
Yeah, please.
Yeah, there's a list of SBA-approved lenders that is not fully up to date, but that's available on SBA.gov. Smaller regional websites will have, I think, more up-to-date lists, but it's important to note that the Paycheck Protection Loan Program is not limited just to SBA-approved lenders. They've expanded eligibility so that other lenders can participate in the program, even if they're not, quote, SBA-approved. So that's why we're seeing more participation here.
When did that change occur, Kathryn? I'm sorry?
That's part of the CARES Act legislation.
Oh, okay. I didn't know that. I thought the CARES Act legislation said you had to be SBA. Okay, last question, and then Jim, we're going to get you off in time. The next question, it's a little bit long, but let me read it to you. Should we be applying to multiple banks and hope one of them comes through? Where a Wells Fargo customer and quote unquote expressed interest over the weekend before they removed the interest link at the $10 billion cap. So again, simplify the question. Should I apply to more than one bank when I'm doing this? Jim, thoughts?
I mean, that's up to you, and I would seek guidance from counsel. You may want to hedge a bit, but I think you want to focus where you have your primary DDA relationship.
What's a DDA? DDA?
I'm sorry, your primary checking account relationship.
Direct deposit account?
Your primary checking account relationship. Start there. If that bank is not doing these types of loans, then move to whatever one you think where you have a relationship that makes sense. And that's what I would recommend. But I'm sure Duncan and Kathryn have other.
Yeah, we've been advising clients to only submit one application at a time. There is a requirement under the CARES Act that you essentially, when you apply, certify that you do not have another application pending under the same program for the same purpose. So we read that as to say this is not permitted under the CARES Act. Submit one application at a time to make sure that you're not going to be in technical violation of that.
Okay. Yeah, I strongly agree with that because I think if you apply twice, you're going to get tossed out of both.
Yeah.
Got it.
So, one question is, what are you recommending for the EIDL? Are you recommending everyone to do that as well, or how are you?
No. So you are permitted to have an EIDL. That's an economic injury disaster loan application pending at the same time that you have a Paycheck protection loan application pending. One thing, though, when you get into the whole question of whether you can refinance the EIDL into a PPL, there is a provision in the PPL that permits that, but it technically only applies for EIDLs that you had before Paycheck protection loans became available. So you can still apply for both, but you can only refinance the pre-existing EIDLs. So just keep that in mind.
Okay, good to know. Jim, it's 10:30 in the morning Pacific time. We want to make you on time for your team call, if that's okay. I mean, you're welcome to stay if you have time, but we just want to be respectful. So
thank you. Thanks so much. I really appreciate it. Sorry I have to run, but Duncan knows more about banking than most bankers do anyway. So you're in good hands with
all right. We appreciate that.
I've heard, Jim, but you take care.
Take care. Thank you for joining us, Jim. We'll talk to you later. We'll keep going with our two guests again. For our audience, thanks for tuning in today. It's an update on the CARES Act and what's going on with the PPP. Dustin, if you want to, there he goes, drops off. And we're going to focus now and move a little bit more towards affiliation. We can keep hitting some banking questions. We appreciate everybody's time. Again, if you have questions or comments, or you agree or disagree with what we're talking about, please let us know in the comment section. And then if you have a question as we go through this, just let us know if it's for Duncan or Kathryn. By the way, you're both attorneys. Duncan doesn't play one on TV anymore, but just so you guys know, Duncan, I think securities was your background. Okay, let me go in, and Kathryn, let's transition a little bit more towards the whole affiliation issue. So confusing. Friday was confusing. The weekend was more confusing. Where are we now? Let me just tell you the last thing I heard, but I'm a layperson, right? So here's the last thing I heard. I'm just going to read a statement I read over the weekend, or got over the weekend. The SBA will deem a minority shareholder to be in control if that individual or entity has the ability under the concern's charter, bylaws, or shareholder agreement to prevent a quorum or otherwise block action by the board of directors of shareholders. What the heck is the latest on affiliation rules, Kathryn, for VC-backed startups?
So the statement you just read is the current state of play. That is an accurate statement. But the question, the $10 million question, is what does that mean? That is the standard for affiliation under the business loan the SBA business loan affiliation rules, which is slightly different from the affiliation rules that they apply for federal contract procurement. Mm-hmm. What it means for our purposes here for determining eligibility for the loan. The loan eligibility is based on essentially the number of employees of the applicant company. And you have to have fewer than 500 U.S. resident employees under the current requirements, with some exceptions. If you have a higher employee threshold under the NAICS code for your industry, that's the North American Industry Classification System, then you can rely on that higher threshold. And some of those go up to as many as 1,250 employees. So that can be significant if it applies for your industry. But otherwise, you have to be under the 500, which means if you are the applicant affiliated with any other company, which can include, in some instances, your investor owners, as well as any of the other companies that those investors also control under the affiliation rules. So essentially the fund and other portfolio companies where they have similar control rates. you would need to aggregate your employees with the employees of all of your affiliated companies for purposes of determining whether or not you're under the 500 employee limit. That's why it matters, because you can see how if you're deemed affiliated with a whole family of portfolio companies, everyone's blown out of the water. There's no chance you're going to meet that.
Right.
So the standard that we've applied, so you will be affiliated with any owner of more than 50% of the equity of the company. That's a pretty, as close as we get to a bright line test in this as anywhere. So that's a concern primarily for private equity backed companies where they may have a majority ownership stake. For venture capital companies where the investments are more likely to be minority stakes, then you look at those blocking rights, the ability to block a quorum or to prevent a shareholder or board action. And where that really becomes concerning from an affiliation perspective is not if there's a general right of, for example, preferred stockholders voting together as a class to approve certain actions. Because if in that case, no single stockholder controls the vote of the majority, then the flip side of that is no single stockholder has a blocking right or a veto right, which means that you can take that action with different combinations of people approving it. So it's not going to be problematic for affiliation with a specific investor. The rights that we have to worry about, what we call negative covenants or blocking rights, are ones that pertain not to extraordinary actions, because those are permissible, but to decisions that relate more to the day-to-day operations of the company. And when those decisions are subject to a veto right or a blocking right that is controlled by one specific investor, or, a fund that invests through multiple funds, but for all intents and purposes is the same investor. And that could be either through shareholder voting rights that are set at a supermajority percentage that by default gives that investor a block, or at the board level, if, for example, you have certain decisions that must be approved by the board, including the consent of each preferred director. If each preferred director has a veto right over that decision, then the investor who has the appointment right, for example, for that director would be deemed to have control and therefore be affiliated.
Wow. Okay. So a couple of things with that. And again, if you're just joining us or joining us late, our guests right now are Kathryn Hickey from PilieroMazza in the Washington, D.C., attorney for 12 years and working closely with a lot of startups in the NVCA on figuring out how to navigate these challenging times. Duncan Davidson's also with us from Bullpen Capital out in Silicon Valley, I think pretty close to Palo Alto, if I remember, Atherton. Investing, serial entrepreneur and investing in a lot of B2B and B2C startups these days, along with a good friend, Paul Martino, across multiple verticals. So thank you again. I just wanted to ask Kathryn, in what you just talked about, so a couple of things on what you just said. As an entrepreneur, many of us at Dream It are serial entrepreneurs as well. I remember signing my stock purchase agreements and all my covenants and everything else. And, if you want to write a check for greater than $50,000 or you're signing a lease for greater than $50,000, you need the permission of X. But you're saying, like, if it's not an individual firm, it's not going to be an issue that I have to deal with the affiliation rule. It's just you need board permission. That amalgamation doesn't count. I hope I'm not asking a confusing question, if you understood my question.
I do understand your question. And I think it's an important point that the existence, there's a multi-factor level of inquiry here. First is, are there any approval rights, investor protective provisions that require special preferred votes or preferred director votes in order for those actions to be approved? If yes, then we analyze the substance of the rights themselves. Certain actions you're allowed to have negative control over without it triggering affiliation, because the SBA understands that they essentially protect the value of the investment. These usually extend to extraordinary actions. So, for example, approving a sale of the company, approving a bankruptcy or a dissolution, approving the creation of a new class of stock or the admission of a new stockholder or the reclassification of stock. Those are all things that the SBA has pretty clearly held are permissible. Even if one investor has a block, it's not going to trigger affiliation. Then you get into the less clear area, which is rights like the one that you mentioned, approval rights over the company incurring debt in excess of X dollars, or one that is really key and causing a lot of heartburn for investors here is the ability to approve the declaration or payment of a dividend, which the SBA has held is too close to controlling day-to-day operations. And if one investor has a block over that, is likely to create affiliation. Again, there's a sliding scale and a balancing test that the SBA applies, but these rights that we've identified as problematic are ones where there is case law where the SBA has held and Office of Hearings and Appeals has affirmed that they rise too far to the level of creating control over day-to-day operations and therefore results in affiliation. So if you have those problematic covenants in place, then the last step of the analysis is the blocking right there, is the veto right controlled by a single investor? Because the point that I was making is, if it's just subject to the approval of a majority of the preferred stockholders and no single stockholder owns more than 50% of that group of securities voting together as a class, then no single investor has a veto, so you won't be affiliated with any one of those investors.
Okay.
If you had a supermajority where it's required 75% approval and you have one fund that owns 30% of the company, then they have a block.
Okay, let me, Duncan, I want to ask you a question. I'm thinking of the workaround I'd come up with this as an investor. You're both an investor and an attorney and an entrepreneur. I'd sit there and think, oh, cool, I know what we're going to do. We're going to amend the shareholder agreement. Let's instantly go in DocuSign, draft a one-page amendment, and let's blow those rules out of the water for 5 seconds and submit. What do you think about that? Or what would you do in these situations? I'm interested in your reaction around affiliation.
We've been asked over the last 4 days these questions.
Okay.
Kathryn gave a very good, very precise answer that may be a little bit in the weeds for a lot of people out there, but boy, she's on top of this. And I think
that's great.
I'm looking forward to the NVCA guidelines that might come out today.
Right.
Last week, Lowenstein out of New York came out with a really good analysis saying they think what's called Section 301 affiliation applies, not Section 103. And the guidance given by the SBA, I think late Friday night, maybe at midnight, agreed with that. So that was good. So we've been following the Lowenstein viewpoint, and the early NVCA stuff, which came out last week, was consistent with it. And so what's come back to us are basically 3 circumstances that we have agreed to and some we haven't. Circumstance 1, the docs say a majority of preferred and the lead investor and investor X. Take that out. You can't have that because that is a specific investor block. So we would agree.
So would you, real quick, would you say to your attorney, draft a one-pager, put it in DocuSign, let's blow that out of the water right here, right now for our shareholder agreement?
But yes, we do. But we do it surgically. Somebody proposed, why don't we do a blanket thing that anything against these general rules doesn't account? It doesn't work. I said, no, don't do that. It's totally confusing. Go read the corrective provisions. Go look at the certificate in Delaware. Go look at the docs and take out exactly when it says fund manager X can block, lead investor, whoever that is, can block. Take them out and go to majority vote. So we've agreed to that. We've had another one which had a weird 70% supermajority voting to handle all kinds of weird contingencies. And we said, just make sure that doesn't put one of the investors into a blocking position, lower that percent to where it works. And they did, and we agreed to that. And that's consistent with what Kathryn's been saying. I'll make one other point. Just so people don't get confused. When they talk about multiple funds have to be aggregated, what they're talking about is one fund manager. So sometimes a venture fund manager like Bullpen might have fund X and Y that invest together, or maybe later growth fund invests on top of an earlier investment. That's aggregated, one fund manager. But that's different than saying 3 or 4 venture funds with separate fund managers, just so nobody's confused. Aggregate one fund manager's portfolio of funds into the number, but don't go across different fund managers.
Got it. Wait, let me restate that to make sure I understand that. If we have Dream Adventures Fund 1, Fund 2, Fund 3, and they're all Dream Adventures, right? Are they going to aggregate? Because I heard somebody this weekend saying, we're going to be fine. We're on our Series B, but our Seed A and B, they're all different funds from the same common investor. Is that, and Kathryn, if you could chime in, now I'm a little confused. I thought I understood. Does DreamIt 1, 2, and 3, hey, come on, bullshit. They're all different LLC names, but they're all DreamIt. That all comes together as one. Is it that way, or are they separate entities for the 20% rule for affiliation?
Yeah, so I agree with what Duncan was saying, which is they would all be considered one because they all are all part of the DreamIt family, the DreamIt common manager, despite the fact that there are different pots of money in each fund. They all go back to DreamIt and they all share the same fund manager. But I think the point Duncan was making, which is important because, again, for completely unrelated funds that are managed separately, you don't have to aggregate all of them together just by virtue of the fact that they are fund investors, right? Duncan, is that consistent with what you were saying?
Yeah.
So I totally agree with that. And just to also kind of bounce off what Duncan was describing, they've done for certain portfolio companies to try to amend the documents. That is consistent with what we've seen and what we've recommended. And we have gotten the question of, well, do we have to go through and figure out exactly which of our covenants are problematic? Can we just sign a blanket waiver that says, if we have anything in our documents that is going to be impermissible and would create affiliation under the rules, then we waive it and we'll just sign that and then we're good. And I view that as problematic. Number one, because, well, for the investor, you're giving up probably more than you need to. And also you don't know what you're giving up. And I think from just trying to build that record of a good faith effort to understand the rules and what you can and can't do, if there's no evidence that anybody has actually examined the documents and understood what's in there and what they can't do, then how do you have any basis to say that you understand what actions you can't subject to an investor block in the future, and what good is that waiver? So I do see a problem with that proposal, and I think that the surgical approach is better for the investor because you're only giving up as much as you need, and also better for demonstrating to the lender and to the SBA that you've made a good faith effort to be compliant.
Cool. All right, let's transition a little more towards Duncan, and then in about 3-4 minutes, we're going to open up for a bunch of questions I have in front of me. And again, if you're just joining us and if you have questions, please put them in the comments and let us know who they are from. Duncan, so just if you give us an update, you were on last week, it was great. How are conversations going with your startups? So, other things that you're hearing about PPP loans and affiliation rules. Can you give us a little view? And again, can you remind us in your portfolio about how many startups are in your portfolio, approximately active?
Oh my gosh, probably 40 still active.
Okay. So 40. Yeah. So 40 active start. And what are you hearing? What's happening on affiliation and PPP loans?
Yeah, to get to your question, people that run companies aren't lawyers, and when they talk to their outside counsel, they get hedged answers as opposed to precise answers. Right. And even if the answer is precise, it sounds hedged. Well, it could be this, it could be that, and it drives them crazy. And they then try to get around that through two means. We talked about one, this blanket omnibus. Don't do that. It just creates more confusion, not less. It's even more confusing than nuanced lawyers. The other is sometimes there's a wink and a nod. Okay, we'll agree to this, but you're going to put it back in later. No, don't do that either. You have to be honest in the process, and you can't play a game like that. So do not agree to that. Do not do that. It's bad advice. But I think last week there was so much confusing advice, and even TechCrunch, and even I think the Axios has put out comments along the lines, most venture-backed companies don't meet the standards. That's simply wrong. Certainly the early stage ones, where you don't have majority control by the outside investors, where the company still has more independence and common shareholders on the board than the venture side, you should be able to get through all this if you just clean up surgically a couple of these named investor individual veto rights. And so I think the confusion on that has been pretty profound, and it's beginning to settle down to a dull roar right now. So I think another day or so, particularly if NVCA puts out the latest guidance, I think most of the companies will be more comfortable understanding whether they apply or don't apply, or whether they're qualified or not.
Okay, terrific. Thank you for that update. So I'm going to transition to questions. We have about 10 minutes left. Let's get into some of the questions from the audience. Again, they'll come up on the screen as we go through them. Let me roll through these in a minute. Here we go. First question is for Kathryn. How do I guess we were just talking about this. How do I amend my bylaws or shareholder agreement? I guess maybe it's the process. Do I talk to my board? Do I talk to my investors? When do I get my attorney involved? How do I do that?
Well, I think that you have to have the conversation to make sure that your investors are comfortable with waiving whatever they need to in order to get this accomplished. We have companies whose investors have said, no, like, we're just not willing to make the change. We're sorry, and in their mind, they've looked at the company and think that they're going to be able to weather the storm without making these concessions. So that's a conversation that needs to happen. I would say consult with legal counsel sooner rather than later, because they can help you, number one, identify where the affiliation risks are, if any. As I think has become apparent in these conversations, it's very easy to get wrapped around the axle in these analyses. It's really nuanced. And so I think getting somebody who can help you trim the fat and focus on, in some cases, really just one or two rights that might be problematic, and that'll help everybody focus on exactly what the ask is for the amendment. And then in terms of drafting, it can be accomplished via an amendment to the document. Make sure that you are achieving whatever approval requirements are required to affect the amendment. So it may be that there's one investor who's the named beneficiary of the right, but if you can't amend the agreement without the consent of a majority of the investors, then you're going to need to bring in other people to make that effective. It's all going to be document specific. Something else that we've seen parties consider is rather than a full-on amendment, to have a waiver document that the investors would sign that effectively operates as an amendment, but it can be a little bit more streamlined from a documentation perspective. And we have had some companies that consider a limited duration waiver, which I think, we've reached a conclusion that may be legally sufficient. But again, the flip side of that coin is understanding, whether optically everybody is comfortable with that, because we think these loans are going to be, publicly scrutinized, and you want to make sure that you've gone into it with a good faith intent to really break the affiliation for purposes of eligibility, not only when you apply, but for, at the very minimum, the entire duration of any potential loan.
Okay, cool. Dustin's producing. Duncan's on the show. Duncan, anything to add to that on, amending bylaws or shareholder agreement? Are you good with that?
Well, I understand the argument for the time-based waiver. I'm recommending to all my companies, don't do it.
Mm-hmm.
And because what will happen is, if they get through this chasm and they then raise another round and it's post the loan, the next investor might figure out how to reimpose some of the things that were waived. You don't need to do it. And the investors shouldn't play a game here. I think Kathryn is right. You don't want to look too clever. That's not what this is about. You should really be in need of this. You should view the fact that you're doing something that's broader than just for you. You got to consider the whole society and the whole moral purpose of this. And cleverness is not useful in that context.
Got it. Okay, let's move to our next question. It was aimed towards Kathryn, but maybe we'll both get a bite at it like that last one. Do you expect the affiliation rules to be amended this week? I mean, you're so close to it. It'd be great to get your opinion. Or do you expect, or do you hope? Either one.
Last week, there was a lot of hope in the venture community that there was going to be some relaxation of the affiliation rules, at least for purposes of the Paycheck Protection Loan Program. So everybody eagerly awaited the SBA guidance that came out at the end of the week. And then we read it and unfortunately realized that it didn't move the needle much, if at all, on the affiliation rules. It was essentially a reaffirmation of the rules that we understood to be in place before that happened. So at this point, I do not think it is very likely that that the affiliation rules are going to be relaxed. Is it impossible? Wow. No, but I think if that were going to happen, it likely would have happened in the guidance that came out at the end of last week and over the weekend. So I think the SBA has kind of doubled down. They said, these are our standards. We're a program that's designed to help small businesses. There's no reason that different rules should apply in this context. Obviously, other than the exemptions from affiliation that are created by the CARES Act, which is, a narrow subset. So I don't necessarily anticipate additional changes to those rules. And Duncan, let me know if you have any other thoughts on that.
I don't think it's necessary. I don't think it's necessary. I think Kathryn's right. The Friday night, midnight, whatever thing from the SBA is probably it. If a gift happens today, we all take it. But I think most of these companies that really are in trouble can use Section 301 rules and guidelines the way Kathryn outlined it and qualify. So further relief is probably not that necessary except on the margin.
Okay, terrific. All right, let's move to the next question. It's focused on Duncan. Duncan, and I don't know if hopefully you see the questions popping up on the screen as well. If multiple VCs invested in a startup, do you find you're working together within a startup with the other VCs to get these issues resolved? Is it you just talking to the founder, I guess, or you're working with the other VCs that have co-invested in a startup? Are you on the conversation on the phone with other investors, I guess?
Yes, the investors are fairly aligned on this. They're all trying to work together to get the company the money if the company's appropriately in need of it.
All right. Oh, that's easy enough. Okay, let me just keep going. We have about 6 or 7 more questions. Let me just keep pounding through them. This isn't directed towards anyone, so it's an open question. It's a audio daily double worth 10 points. Now, Kieran Miller asks, will the SBA, okay, it's a little bit long. Let me read it. Should come up on the screen. Will the SBA increase the forgiven amount beyond the 2.5 times average payroll and other qualified expenses if the company guarantees the additional amount will go towards new hires and agrees to be audited for that? Kathryn, you want to take that? Any thoughts if they're going to go past the 2.5 rule?
Well,
calculation. So
just to clarify, the maximum amount of the loan is 2.5 times average payroll.
Right.
So the forgiveness can't go beyond the maximum amount of the loan. But what I think the question might have been getting at is because the forgivable amount of the loan could be up to the maximum, but it can be less depending on how the funds were used. The guidance has indicated that to the extent the funds are not put towards payroll costs, but are put towards other allowable uses. So you can use these funds to pay utilities, mortgage, interest, et cetera. But to the extent you don't use it for payroll, it's going to potentially impact the amount that could be forgiven just based on the funds available. I really do think the emphasis is going to be on payroll costs. So there's a possibility, depending on how much is actually available to work with, that the other allowable uses might be subject to forgiveness at some higher level than they've already indicated. But I believe the guidance right now has said don't count on more than 25% of those other allowable uses to be forgivable. And then they can certainly change that depending on where things look when it comes to process those forgiveness applications.
Okay. I have a question for Kathryn. I think I have to go in a second anyway, but this is something I try to figure out. The 2.5 times month is really 11 weeks. You get 11 weeks of money, and the payroll base you look at has a 100K cap in it for people paid over 100. On the other hand, the forgiveness is over 8 weeks of spending.
Yeah.
However, Kathryn, I don't think they have the cap anymore. I think it's 8 weeks of your real payroll plus rent and utilities. Versus 11 weeks of your adjusted downward payroll. Is that
That's
correct?
You are correct that those are slightly different measurement periods. I don't have anything else to say.
And also, they don't apply the cap on the forgiveness side, just on the loan amount side. I think that's right.
That's right. Yes.
Okay, so this is huge because if you think about it, 8 weeks, 11 weeks, will they ever get up to the full amount? Probably will, particularly if you do what we're saying to our companies. If you take the loan, hire back the furloughed employees you need. So you're actually trying to live up to the spirit of the SBA loan in the first place, which is paycheck protection of individuals. And I think you will get almost two, if not two, the full forgiveness.
Yeah, I think that's right, Duncan. And you mentioned, I do also want to emphasize, to the extent people aren't aware, that the loan forgiveness is subject to decrease if your workforce over the course of the loan, so if you lay off workers or if you decrease salaries by more than 25%. So I think that really gets to exactly the intent of this, is to encourage employers, to the extent possible, to use this money to keep your employees around and to continue paying them with, consistent levels of salary. Because if you don't do that, it's just going to impact the amount of not your loan eligibility, but the forgiveness eligibility.
Okay. Steve, I have to go. I've got a hard stop in about 30 seconds. So
no problem. Kathryn, can you stay on for 2 minutes? Otherwise, we'll wrap it up. Thank you, Duncan, and stay well. And thanks for being on again. Kathryn, do you have a few more minutes?
Yeah, I have probably about 10 more minutes if you need to get through any other questions.
Okay, so we have a couple of other questions. I'll ask you this next one. So which is more favorable to the employee? This is different than we've been talking about. A shared work program, unemployment filed by the company, or have the individual apply for partial unemployment benefits? Is that something you feel like you could tackle?
This is kind of outside my lane. I'm not a labor and employment lawyer, so the interplay of the unemployment versus the shared work program, I apologize.
Not a problem. Not a problem. Let's okay. How about this? Let's wrap it up here. We're right at 2:00. We've burned an hour of your time today, which we greatly appreciate. Let me just say some closing words. Any other, just while you're here and you have the platform, any other thoughts or remarks that we haven't talked about you think startups should know?
Well, first of all, I just have to say, I think it's really fantastic that organizations like Dream It are trying to put this content out there, because we know there's a lot of confusion. People are trying to get this right for the most part, but it's not necessarily the most intuitive process. So I just want to, say thank you to you guys for doing this.
No, thank you.
And the other piece that I do want to echo, kind of consistent with what Duncan was saying, is the attractiveness of this loan is very real. And I think a lot of people at the outset were focused on, just how do I get this money? But it is really important, if you are applying, to make sure that you have a true defensible case of the necessity of the funds. Necessity is a requirement for eligibility. So that can mean a lot of different things for a lot of different businesses. But it is something to focus on and, make sure that at a board level, there has been at least a consideration of that point and a finding of necessity for the loan you're applying for.
Okay, terrific. And no, we appreciate you being on. We know you're so wickedly busy right now, so we appreciate it. So let me just a couple of closing comments. Every day at Dream It, we work with and invest in great early stage startups. Today, we've been sharing great ideas and advice from some of the best in the business. Again, right now, we're focusing all of Dream It for Dream It Live on these challenging times and how can we help bring great content and great guests on and talk about that. So thank you again, Kathryn. Just to wrap things up completely, if you have more questions, reach out to us on Twitter or on our comments. Check out the latest Dream It doses on YouTube for great pragmatic techniques. They're about 5 to 7 minutes each. They're topics we find startups make mistakes about again and again, so we can record and create these Dream It doses. Catch our upcoming and past Dream It Live episodes. You can go to dreamit.com/live, where you can sign up to get alerts. We'll have more coming out this week, and we really appreciate everybody's time. Thanks for watching, Kathryn. Thanks for staying with us till the end. Have a great afternoon.
Thank you.
Thanks. Bye-bye.